Hi, I'm here today with Todd Whatley to talk about estate planning for seniors, elder law for seniors too. And the topic we're talking about now is power of attorney. Todd, welcome back. Thank you for your
Thank you.
time.
Thank you.
Um, Todd, power of attorney. I mean, everybody's heard of power of attorney, and I always thought that it was something that you only had to think about when someone is very ill or something's happened there with their health. Is that correct? Is it just for those kinds of situations?
Sure. Yeah, that's a great question. And I think people are surprised because first, a power of attorney is a legal document that you appoint someone to be able to handle affairs for you. You don't give up anything. When you do a power of attorney appointing someone, you simply added someone to be able to do that. And almost always, everybody picks their spouse first because that kind of makes sense. You have jointly owned accounts and that person knows you better than most. And so, therefore, typically it's your spouse first, and then you need to name backups. But when you name just one person first and then have backups, it's that first person who has the power to do whatever. And yeah, it is imperative once you become older and sick and start having problems. And once you see that you're going to become incapacitated, it is absolutely necessary that you have a power of attorney for finances and for healthcare. But we don't know what's going to happen this afternoon. When I leave the office today, I could have a car wreck and I could be so injured but not dead that I can't answer questions. I can't do anything. And so someone needs to be out there to legally be able to transact business and do things. And that's why you can't do a power of attorney if you're under the age of 18. But on your 18th birthday, when my kids turned 18, they were sitting in my law office doing powers of attorney, naming their mother and I as their power of attorney, so that if they were in a car wreck or if something were to happen, or they're just gone, they went on a college trip to Europe and something comes up here that they need my son's signature as his power of attorney, I could jump in and I could do that. And a lot of older people travel a lot. And if they're gone, it's very inconvenient to have to drop what you're doing, come back and sign something where you could just say, hey, my son is my power of attorney. He can go sign it. It's extremely convenient, but once you get older, it becomes absolutely necessary that everyone have power of attorney. If you, and so that's the answer to that question. I think I know what you're going to ask next, and
Well,
I'll
yeah.
answer.
Why does an estate plan need a power of attorney? That was
Yeah,
my
just
question.
because everybody needs it. It's part of your, it's really not estate planning, but it's part of your estate planning documents because estate planning primarily is at my death, here's what happens. Power of attorney is while you're still alive. Your power of attorney dies when you die. And so it is crucial that your attorney, and it amazes me when people bring in their estate planning documents from some other attorney and there's not powers of attorney in there. And I'm like, you've got to have power of attorney because my goal is for my clients to never go to court. Okay. Don't go to probate court. And we talked about that in a previous series, and don't go to guardianship court. And that's the question I probably will ask is if you don't do power of attorney, what happens? Well, then if you become incapacitated and you don't have a power of attorney, we have to file a lawsuit against you. We have to go to court and say, Judge, this person's incapacitated. There are no documents in place. We need you to appoint someone to now be in control of their estate. It's ugly, it's embarrassing, and it's a lifelong commitment with the court every single year to submit accountings, physical status report. Everything is in public record for everyone to see. And all of that can be avoided with a power of attorney.
Okay, and I guess my next question would be, what different types? There are different types, aren't there, of power of attorney, and what are they, and how do they work?
Right. There should be only one type, okay, but there are two, and the two types primarily affect when the power of attorney comes into play. Okay. So there is a immediately effective power of attorney, which that makes sense. It becomes, as soon as you sign it and it's notarized, it's effective. There's also a springing power of attorney, which means it springs to life once something happens. And if I were to ask clients, do you want the immediately effective POA or the springing POA? Almost all of them will pick springing. But that's a problem because that springing event is typically having a physician determine that you're incapacitated and can no longer manage your affairs. Then and only then does your agent come into power to be able to do things. And if I were if I had given you that option, you would say, yeah, that sounds great because I don't want my kids or anyone involved in my stuff until I need them to. And so, yeah, let's do that. The problem is with dementia, as you start going through the stages of dementia, about halfway to 2/3 of the way, when you really start making bad decisions and need a power of attorney, it's at that point that you become very paranoid and accusatory of people in your life. You think everyone's stealing your money because you can't find the money or you can't find your watch or your earrings or whatever. So someone stole them. And you know that you're declining and you're afraid your kids are going to throw you into a nursing home. And so with a springing power of attorney, you're making bad decisions, you need help, but your agent can't do anything until we now take you to the doctor, prove that you're incapacitated, and take over. Basically, it's a hostile takeover at that point. And if you don't go to the doctor, we can't get the letter from the doctor. Therefore, this springing power of attorney can never come into effect. Our only option is a guardianship. And I just talked about how we don't want to do guardianship. So I encourage my clients, don't do a springing power of attorney, just do an immediately effective, with the understanding you don't lose any power and your agent can only do things that are in your best interest. So yes, you are naming them, and it's typically your spouse. Your spouse hopefully is not going to do anything against you, but even if it's your kids, they have a fiduciary duty to you to not steal your money, not take advantage of you. They're there to help you, and the law supports that.
Wow, very interesting, very interesting. So, in summary, one of the benefits and the limitations of POA.
Well, the benefits are huge. It avoids guardianship, okay, which is court, which is thousands and thousands of dollars, a lifelong commitment with the court. You don't get to choose in a guardianship. The judge picks for you. And there could be some family dynamics there that aren't apparent in court. And so you know who's going to make the best financial decisions for your financial POA. You know who's going to make the best medical decisions for your medical POA. You get to choose. The downside is a power of attorney is revocable. You can change your mind. As long as you have capacity, you can change your mind. And many times we as elder law attorneys see people change their mind frequently depending on who's in their ear, which kid's talking to them, which kid's trying to take over or steal money from mom or whatever. You know, they want control over mom, and so they get mom to change her mind frequently. That's mainly the only downside to it is you can change. And if someone does change their mind repeatedly, we then still have to go to court. But the downside to the POA, there's a little bit of cost up front, but it's super convenient and it will truly make your life easier and it will make the kids' life easier so they can immediately jump in and start doing things when they are needed.
Well, that's really, really, really interesting. And I guess many people wouldn't have considered the idea that you should have a power of attorney from the age of 18 onwards. It makes a lot of sense. Mm-hmm. Todd, thanks very much for your time and the clear and concise explanation of the issue. And we'll see you in the next video.
Okay, thanks.
Cheers. Bye-bye now.